SJC-11551, Commonwealth versus Lopez.
Good morning, Mr. Keegley. Take your time. We're getting folks settled in there, so why don't you wait a moment until everyone's seated, and then you can get started.
Very well, Your Honor.
No doubt you attract a crowd. All right, you may proceed.
Good morning, Mr. Chief Justice. Good morning, Your Honors. My name is David Keeley, and I'm here today on behalf of the defendant, Gregorio Lopez. Your Honors, unless the court has other plans for me today, I'd like to address the issues in the order in which they appear in my brief. So starting with the exclusion of the victim's prior violence towards Desiree Ortiz, my first argument is the exclusion is a basic constitutional error because without that evidence, the defendant had no defense to the charge of first-degree murder.
Well, what was his defense? Wasn't his defense, I didn't do it? They conspired to pin it on me, but I didn't do it?
Well, that's how it turned out in closing argument. Okay. And the closing argument tried to highlight the inconsistencies between the four main witnesses, but that was, well, that's what he was left with, Justice Cordy, without the evidence of the victim's violence towards Desiree.
So the go ahead.
No,
go ahead.
Well, wouldn't there have to be, didn't the judge keep on telling him, at least 3 times during the course of the trial, that I will revisit this question about the prior acts of violence, whatever they might have been.
Yeah.
But there's first got to be some evidence of either self-defense or defense of another. Where was the evidence of self-defense or defense of another?
Well, Judge, there's Desiree testified that the victim came into the room, threatened Mr. Lopez. There's evidence from a witness, Vega, that Mr. Lopez, the defendant, told her, victim's got a gun in that bedroom. I mean, that statement came in for without limitation. And also, Desiree acknowledges her grand jury testimony that out in the hallway, the victim threatened her to hurt her and also threatened to hurt everyone else in the apartment. So take that evidence, if you combine that with the victim's violence towards Desiree, and by the way, there was a sufficient offer of proof on that, which we can get to, Your Honor.
But didn't the defendant leave the apartment?
Yes, he did.
And he was gone for 20 minutes?
Yes, that's according to the evidence.
Doesn't that dissipate the evidence that you've just pointed to?
Well, in a legal sense, it does in some measure, but the defendant has a constitutional right, due process right to a fair trial to explain, in other words, his subjective frame of mind with regard to some of those mitigating issues that Your Honor has mentioned.
Do you agree that he had an obligation or a duty to retreat?
Oh yes.
And he
Yes.
did. He left. He left the
Left
building.
and came back.
He could have gone to the police.
Right.
And he didn't.
Correct. That's correct.
Well, you don't, the duty to retreat is true as to himself, but isn't part of your argument in defense of another?
Well, that's of the two, self-defense and defense of another. Defense of another is more plausible in this case. So yes, he does. There is evidence that he leaves and comes back, but in this particular case, that in my mind, that tends to sort of dissipate or at least meet or tend to rebut the going away in the first place or the premeditation element of first degree.
But when he comes back on the defense of another,
Yeah.
He comes back, they're in the hall, it's just, even assuming everything that you say,
Yeah.
where does it look like she's needing defense?
Well, based on
With opening a door and taking a gun and shooting it.
Well, based on the the evidence that came in at trial. It's doubtful whether lawful defense of another was in play here. But to defend the case in any way, shape, or form, Mr. Lopez should have been allowed to put his subjective thought process or his frame of mind. In other words, explain to the jury why it was that he felt the need to protect Desiree.
I understand that your client has a right to a defense, but he has to comply in some respects with the rules of evidence. He doesn't get to put in whatever he wants just because he has a right to a defense. He has a right to a defense that complies with the rules and that is based on evidence that's otherwise relevant in the case. I mean, it just can't be, I did it because I heard that he beat her up before.
Well, Your Honor, I mean, I guess I'm going to repeat myself. It's relevant to a subjective frame of mind, which is, frame of mind is always in play in a murder case. And the case is...
I know that, but, you know, that frame of mind didn't suggest that there was any need to act on that at that moment.
But he doesn't, again, Your Honor, he doesn't get a chance to put his subjective frame of mind is an element of defense of another and self-defense. And it's also relevant to the greater question of malice. And that's his only way to defend.
He can get his state of mind in by testifying.
Well, but
But if you want to get this other evidence in, you've got to establish a basis for it.
well, there's no burden on him.
No, but
there's no burden.
But he's got a burden to present some evidence of defense of another.
Well, and
self-defense.
And a part of that is, and even if it's an imperfect self-defense or a very weak self-defense, it's just why have a trial if he's not, I mean, why have a trial if he can't put in his subjective frame of mind? It's a due process. He has the very at the very least, he has a due process right to put this evidence in. There's no other way to defend the case.
Well, I mean, but what you're essentially asking us to do is to recognize we have the idea of a battered woman defense, but you're asking us to essentially say the chivalrous boyfriend of a battered woman has a defense for killing the batterer. I mean, that's basically, isn't that what you're essentially asking?
No, I don't think I am, Your Honor. What I'm saying is that for admissibility, relevance for admissibility, it's a very low barrier, and as trial defense counsel astutely told the judge, let it in, and if it doesn't rise to the level of requiring a jury instruction, don't instruct on it, but at least allow us to put our case in, and then if the instruction's not forthcoming, so be it. But the judge just gutted the defense.
The evidence would have been what? You call a witness and say, do you know that so-and-so beat this person up some point?
Well,
before?
Desiree would have been asked on cross-examination.
Okay. Did he ever beat you up?
She would have, and
she would have said?
the expected reply, I mean, based on the grand jury, was that he beat her regularly, and she was fearful of him. He had hit her in the face once. He had bruised her face, and Mr. Lopez, the defendant, had seen those bruises, which probably would have been around January, 2 months before the shooting.
So how did this make a difference in the outcome of the case?
How would it have made a difference? Well, at least the jury would have had some way of assessing what his thought process is. Why did he do what he did?
Well, I guess I'm asking if you think the outcome would have been different if the jury had heard that the defendant had beat her up a couple of times.
It might have been, it's impossible to say because the jury didn't hear the evidence, Justice Hines, and I'm trying to answer your question.
But I mean, you do have to establish that there's some prejudice as a result of the judge's error, don't you?
Well, I think the prejudice is that if he can't explain his frame of mind, then the jury has no way of knowing what it is, and to me, that's prejudicial.
Well, don't you have to show that if the judge had let this in, that it would have had a positive effect on your client's case.
Well, it may have had a positive effect with regard to first degree and the difference between first degree and second degree, and also possibly would have affected or negated the extreme atrocity and cruelty element under that theory. So and it is somewhat speculative to say that it would not have been prejudice. It has to be non-prejudicial beyond a reasonable doubt. And again, there's no defense in the case without an explanation of why he did what he did. And the judge didn't allow him to do that. Why have a trial? I mean, it's as simple as that in my mind.
I mean,
Your Honor.
the mere fact that the case is indefensible doesn't necessarily mean that you're entitled to create one. I mean, the problem, put aside the extreme atrocity or cruelty, but
Right, the judge.
I mean, you have a guy looking around, making telephone calls, trying to find a gun, and then he finds a gun, and then he blows with a shotgun in the chest. I mean, that's a pretty strong premeditation case.
The facts are the facts, Your Honor. I mean,
I understand
and
you've
you
got to
go
play
with-
the
you
cards
bring
you're
with-
dealt, but the question is, what you're basically saying essentially is that you would, what may have mattered, you essentially are saying, is the jury would have said that since he was a batterer of her, that he is in some fashion deserved it, and therefore the defendant should get some break from the jury. I mean, isn't that basically what you're asking us to say?
I'm
you're
not
entitled
saying
to?
that. I'm not saying that the victim got what he deserved. I'm not saying that at all. Not at all. I'm
But how would we even know that the evidence of the relationship between the victim and Deidre, I guess, whatever her name was?
Desiree.
How do we know that evidence of abuse would have even had any effect on the defendant? I mean, maybe he didn't care about what went on between them, unless he got up and testified.
Well, he said there's evidence, he made a couple, he told two people that he did what he did to protect her. But that doesn't tell his story. His story is, why did he feel the need to protect her? And without that evidence, it's not even a full picture, and this court says and that, by the way, that's why I cite adjutant and chambers, not for first aggressor. This is not a first aggressor case, but for the more general proposition that frame of mind is relevant in a case like this where there's a victim's prior violence towards someone. It's relevant to malice. It's relevant to the question of murder. It's his only chance to defend the case. It's relevant. It's admissible. The relevancy bar is a low one, and so I think the judge made a constitutional error by barring this evidence, both under the federal cases I cite in my brief, and also under the Massachusetts cases that I cite in my brief. So again, I think the error is reversible. So with that, Your Honors, I'd like to just briefly move on to issue 2, which is actually just, issue 2 briefly, Your Honors, is because of the erroneous ruling, the prosecutor was allowed to argue motives that were based on facts in the case. There's no suggestion that the prosecutor crossed any bounds. In fact, this issue probably doesn't even deserve attention as a special issue, only that there was a spillover. Here's the judge's error affecting closing argument. Defense counsel can't get up there and say, wait a minute, it wasn't anger, it wasn't humiliation, it was a desire to protect Desiree because of what had happened, the victim's violence. So that's all we really have to say on issue 2. And moving to issue 3. We just asked the court once again to take a look at the question that was raised in the Commonwealth versus Berry concurrence back from a few years ago or 2 years ago, and find that frame of mind should always be relevant in an extreme atrocity and cruelty case. It's already relevant for intoxication and for mental impairment. And it's also relevant on the first Kunin factor. I would argue that frame of mind is relevant on the number of and manner of blows. And so, and frame of mind is...
Well, it's already admissible on the question of malice,
That's right.
the specific intent to kill. But you want an instruction that says that it's a specific intent to commit murder by extreme atrocity or cruelty.
Well, I think I basically would ask the court to rule in conformance with the Berry concurrence. I don't have different arguments than that, to be quite frank, Your Honor.
Okay.
I just think that if it's going to be relevant to intoxication and mental impairment, and the first Kunin factor, then perhaps it should be across the board and just allow frame of mind in on the extreme atrocity and cruelty question.
But then you would be still have a guilty of first degree on the grounds of a deliberate premeditation.
Well, in this particular case, Your Honor, well, not if you agree with me on issue number one. Then issue number three may not. I don't know if the court would even address that. But the error here gutted the defense, just so I cite some state cases, Vardinsky and some of they're all in my brief, Your Honor. And I think that in fairness and Mr. Lopez's trial was unfair in a basic way, lacking that evidence. And I would ask the court to reverse his conviction and award him a new trial on those grounds.
Okay, thank you.
Thank you, Your Honor.
Ms. Lewis, good morning.
Good morning, Your Honors. May I please the court? Sarah Lewis on behalf of the Commonwealth. With me today is the trial prosecutor in this case, Assistant District Attorney David Fredette. We are asking this court to affirm the defendant's conviction for first-degree murder based on the theories of both deliberate premeditation and extreme atrocity or cruelty. As my brother began, the crux of his argument here is that the trial judge erred in excluding the evidence of the victim's past violence or alleged past violence toward Desiree. This argument fails for two primary reasons, the first being that there was an insufficient proffer of specific incidents in this case, as was alluded to before. And second, there was simply no evidence of self-defense, defense of another, or reasonable provocation in this case. For such evidence of a victim's past violent conduct to be admitted, self-defense must be a contested issue. And as I just noted, it was not in this case.
Now, what do you say about his argument that it may bear on the first Kunin factor, indifference to or taking pleasure in a victim's suffering? He claims that if the jury had known that he was acting to protect Miss Ortiz, that would bear on whether or not he took pleasure in the victim's suffering or simply was trying to protect his girlfriend.
I would first respond to that by saying there has to be an evidentiary basis for the evidence, as Justice Hines stated, and here there's not. And so on those grounds alone, the evidence was inadmissible. Without an evidentiary basis, I would point the court's attention to Commonwealth versus Benjamin, which is 430 Mass 673, where this court said that permitting the defendant to present evidence of his perception of the victim's character and the effect it had on him poses the risk that negative information about the victim may divert the jury from focusing on their basic task by causing them to consider the victim's character and worth. And I think that this evidence, again, without an evidentiary basis, even if it did bear on the first Kunin factor, would divert the jury's attention.
So that then becomes a 403 analysis of balancing the risk of prejudice to the Commonwealth versus the benefit to the defendant?
I'm sorry, Your Honor, could you repeat that? I didn't hear
That
the-
becomes essentially a Rule 403 analysis of the prejudice to the Commonwealth from focusing on the victim being a bad guy versus the benefit that it may have in terms of the evaluation of the Kunin factor. Is that what you say should be done here?
Yes, exactly. The defendant does have a constitutional right to present evidence in his defense, but that does not detract, as the Commonwealth argues in its brief, from the judge's authority to assess the relevance of the proffered evidence and to exclude the evidence that's of marginal relevance. And here, going back to the first point, this evidence is marginal, where there is no evidence that the defendant had a right to act in self-defense or to defend Desiree. There was no imminent threat towards Desiree, if we want to talk about defense of another. The defendant, in terms of self-defense, retreated. He retreated to get a gun, returned, calmly, deliberately walked down the hallway of 43 Mozart Street. He paused to allow Griselle to get her baby and bring the baby into a Jenny's room, another one of the roommates. He then opened the door and without warning fired the shot. There's just no basis to admit this evidence here, even if it could arguably bear on the first cunine factor.
Did the defendant at trial argue to the judge that it bore on the first cunine factor, or is that simply an argument made on appeal?
The way I would address that is he did argue against an instruction on extreme atrocity and cruelty. And in that argument, he said that this evidence should have come in. The defendant argued that the evidence was relevant to state of mind and therefore extreme atrocity and cruelty, and without the evidence, the judge should not give such an instruction.
But that was at the charge conference.
Yes, that was at the charge conference.
But before, when the judge, before the cross of Ms. Ortiz, when it would come in,
Right.
did he ever inform the judge, Your Honor, this is why I'd like to be able to do this?
I will note that the premise of his argument was that it should come in as it bears on the defendant's state of mind with respect to defense of another and self-defense. After the judge made his ruling, the defense counsel said, and I think it also goes to first-degree murder and second-degree murder. But that was it. And I can give the case site for that. I know it's in volume 3 of the transcript. I don't have the exact page number.
But the first time that he made reference to it being relevant to extreme atrocity or cruelty sounds like it was at the charge conference.
It was at the charge conference. Yes, you're correct, Your Honor. And so the way that argument's developed on appeal is that it's raised for the first time on appeal. If the court has no further questions on the first issue, I will just briefly touch on the closing argument, as my brother did. And the prosecutor's argument was correct. And there was no improper comment on the excluded evidence. I would point out that the prosecutor's argument would have been plausible had the evidence come in, and point the court to Commonwealth v. Carroll, 349 Mass 547, where in that case, the court commented on the fact that the closing argument would not have been, the motive that the prosecutor argued in that case would not have been plausible had the evidence not been excluded. And we just don't have that situation here. So there's no error in the closing argument. Turning to the issue of extreme atrocity or cruelty, as Justice Gantz pointed out, the jury convicted the defendant of deliberate premeditation in this case and necessarily found an intent to kill. And therefore, even if this court were to revisit the crime of extreme atrocity or cruelty, it would have no bearing on this case. It would also have no bearing on this case as similar to Commonwealth v. Spinucci, where there's ample other evidence of the defendant's state of mind and also ample evidence of the cunine factors. I think it's important to note that the defendant not only without warning shot this victim, but he returned to the landing and kicked him twice, returned a third time, cursed at him, and grunted at him. I think that bears substantially on his indifference in this case, which is one of the cunine factors, and also relevant to his state of mind. With respect to the cunine factors, also the victim was still breathing when he spoke to Desiree, and the medical examiner testified that it was possible for someone with the victim's injury to be conscious for some time. And therefore, where there was ample evidence of extreme atrocity or cruelty, that conviction should be affirmed, as well as the conviction of first-degree murder based on deliberate premeditation. If the court has no further questions, the Commonwealth will rest on its brief.
All right, thank you.
Thank you.
We'll take our morning break.